And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the February 9th, 2021 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman, and sitting with me today is Justice Sukyoung Shin and Justice Singh, and we will be your panel for all 6 cases this morning. Check that, all 5 cases this morning. Calling our first case, it is Commonwealth versus KANTE, matter number 2020-P0438. We will hear first from counsel for the appellant.
Good morning, Your Honors. Attorney Grant, Ann Grant for MAHAMADOU KANTE. May it please the court. I briefed 3 issues on this appeal, and I'd like to start with the Armed Career Criminal Act issue because even though I have lots of complicated legal analysis in my brief about this, there is a fairly straightforward issue before this court, and that I think I can address succinctly. Your Honors, as this court knows, the Armed Career Criminal Act exists to allow the Commonwealth to enhance, or allow a judge to enhance a defendant's sentence if they're found guilty of a firearms offense, and the Commonwealth proves beyond a reasonable doubt that they have a predicate, a prior conviction for a violent crime. Now, in this case, Your Honor, the Commonwealth attempted to prove that Mr. KANTE had a prior conviction for resisting arrest violently. They failed, however, to show that with sufficient evidence. The reason for that, Your Honors, is because they had 2 officers testify at the ACCA trial. The first was Officer Smith, who testified to a nonviolent theory of resisting arrest, essentially that Mr. KANTE had run across traffic and officers had pursued him. Officer Reed testified that Mr. KANTE attempted to push him. Now, the Commonwealth failed to show which of these theories supported the conviction from 2012, where Mr. KANTE pled guilty to resisting arrest. And in fact, the Commonwealth supplied evidence that showed that it was the nonviolent theory. That's because the Commonwealth submitted into evidence the contemporaneous police report from the incident. And that police report showed not Officer Reed's testimony about the attempted push, only a theory of evidence that shows that Mr. KANTE ran from police across traffic. For that reason, they failed to show that Mr. KANTE violated the ACCA and that he qualified for enhanced sentencing. There's an additional reason that the Commonwealth failed to show that sufficient evidence for ACCA enhancement, and that's because Officer Reed did not testify to conduct which qualifies as violent under the statute. Under the statute, the Commonwealth was required to show that there was force of sufficient magnitude that it was capable of causing pain or injury. Officer Reed didn't testify to that type of force. What he testified to was that Mr. KANTE attempted to push him. That is insufficient for violence under the ACCA and doesn't justify sentence enhancement. If there are any,
we don't have to go there if we agree with you, though, that there wasn't proof that the basis of the conviction was the non-force.
Yes, absolutely, Judge. That's right. That's right. The first issue about them showing 2 theories and being unable to prove which one of them underlay the conviction in 2012 is enough for this court to say that there wasn't enough evidence to prove him guilty of violating the ACCA.
Okay.
If there are no other questions about the ACCA sections, as I noted, I have many arguments about them in my brief. Happy to answer any questions about those. If there aren't any questions, I'll move on to the defaced serial number. So, Your Honors, with respect to the defaced serial number conviction, in the normal case, the Commonwealth is able to show that a person defaced the serial number or knew that the serial number was defaced, because in the normal case, the gun is visually evidence of that. What's unique about this case, Your Honors, is that the gun is rough all over. There's no indication that it ever possessed any type of serial number. A lay person wouldn't know that by looking at this gun. And there was no evidence that Mr. KANTE knew more than a lay person. And so this case, there was simply insufficient evidence to establish that Mr. KANTE either defaced the serial number himself or possessed the gun knowing it had been defaced. In addition, there were 2 unconstitutional jury instructions given in this case. The first was on the theory that if you possessed the gun, that was prima facie evidence that you defaced the gun. But the only way for that to work, for that to be constitutional, is if there is a strong logical connection between fact A, possession, and fact B, defacement. And in this case, there was testimony by officers that the only way that this gun, or that the way that this gun was defaced, is that somebody applied a chemical to it or some sort of brushing tool. We're talking about a metal imprinted serial number here. Now, there was no evidence in this case that Mr. KANTE had access to either of those types of things, chemicals or brushing tools of any kind. And so no evidence that he did this himself.
I'm sorry to interrupt, but would you agree that the model instruction essentially tracks the statute?
It does, yes, Your Honor.
So is your challenge then to just the instruction, or is your constitutional challenge effectively to the statute itself?
When it comes to the facts of this case, Your Honor, it could be to both. In this case, I focus on the instruction because that's what was used at trial in order to guide the jury. And on the facts of this case, where we have a gun that is rough all over with no indication it ever possessed or was manufactured with a serial number, you can't use that prima facie evidence because the Commonwealth, it cannot establish the first fact that the inference is logical. It can't say that possession alone is enough to show that somebody actually defaced a serial number. And
So
in that
how
context,
would you distinguish, I'm sorry to interrupt, but how would you distinguish the Ferrer case?
in that case, Your Honors, the court doesn't describe that gun. There's no analysis in that case that suggests that the gun resembles the gun here. In most of these firearm defacement cases, the courts deal with them in maybe a paragraph or so. The cases that mention the gun and what it looked like are the ones that I cited in my brief. You've got Grant, Rupp. Those cases show that the serial number was blurry or scratched off, so it was visually apparent from the gun itself that something had been done to manipulate it, to deface the serial number. In the Ferrer case, there's no commentary on how the gun appeared. Simply, I think the fair inference is when they say that the Commonwealth presented the gun itself to the jury, the inference is that you could tell by looking at the gun that a serial number had been removed. And there's no case like this one in Massachusetts that I've seen or that the Commonwealth presented to suggest that if a gun doesn't show a serial number at all or any markings whatsoever, such that a layperson would know it ever had a serial number, that this is a constitutional instruction or that the prima facie evidence should hold in a case like this.
You keep reverting to this language such that no layperson would know that it had a serial number. Where are you getting that language from?
I'd suggest, Your Honor, that is what the Commonwealth has to show, unless they had proven that Mr. KANTE had specialized knowledge that this firearm would have had a serial number. Then what we're talking about is what a reasonable layperson would know about a gun. And in this case, there's no evidence that just a regular person looking at this gun would know this must have had a serial number that was removed. So
I'd also the law requires that every firearm have a serial number, right?
Yes.
He's charged with that knowledge. Possessing a firearm without a serial number is prima facie evidence of his knowledge that it's been removed, and I'm having a hard time seeing how he's rebutted that presumption.
Well, Your Honor, I would submit that the law says that a gun must be manufactured with a serial number and that he's not charged with violating that statute. What he's charged with is the defacement statute, which does require knowledge.
He's charged with the knowledge that every firearm must have a serial number, and this one, there's no dispute that it does not, right? So it's only if it's obvious defacement that you're guilty of this crime?
Your Honor, I think that it can vary depending on how the firearm appears. In this case, I think because the firearm has no indication whatsoever that it possessed any writing, it's not visible at all by holding the gun, touching the gun, nothing, that extreme end is insufficient to show knowledge. And even though there is a statute saying it has to be manufactured with a serial number, this statute, the defacement one, requires knowledge that it was removed, or no guilty knowledge of that, or pardon me, guilty knowledge of that. It's in the statute. There's an element of knowledge required in the statute, even if there is a separate statute that requires them all to be manufactured this way.
Right. So he's presumed to have that knowledge by virtue of possessing a gun without a serial number. right? I mean, it seems, I take your argument to be that the removal of this serial number, the defacement has to be obvious. But if somebody did a nice, tidy job of it, then someone's not guilty. Right? I mean, how do you draw that line? It just, I'm not understanding.
Well, Judge, I would submit that this statute requires receives a firearm with knowledge that the serial number has been removed. That language requires special knowledge that this serial number has actually been removed from this gun. But going to the second part of that question, Your Honor, which is actually moving on to another part of this issue, Your Honor, is that if either of the jury instructions given in this case were unconstitutional, then his conviction has to be vacated. So under the first jury instruction, the court instructed the jury that if he received the gun, that could be sufficient prima facie evidence that he defaced it himself. As I noted, there's no evidence he defaced it himself. So even if this court thinks that the second version of the jury instruction, which was also given, would be acceptable under the statute, the fact that both were given means that it has to be vacated. So I would argue that is another reason why this conviction must be vacated, Your Honors. In addition, there's a burden shifting problem with these instructions in that if that strong logical connection isn't there, if that first part that the Commonwealth showed that he possessed it isn't enough to establish that he had to have removed the serial number himself, that burden shifts to the defendant when the instruction requires him to provide some sort of contrary evidence on that point, which is an unconstitutional burden shifting. Your Honors, I would like to get to my third issue, if that's acceptable. I'm happy to answer any of the other questions on the defaced serial number. Okay, so moving on to the suppression issue, Your Honor. The first question in this case on this issue was there an illegal arrest? And the Commonwealth has styled this case as being like the ones where the police are allowed to rely on R&B records that turn out to be false. But that's not what happened in this case. In this case, the testifying officer says that the officer who looked at the records said those records showed it was expired. Now, because the records are not actually inaccurate and they show that Mr. KANTE's license was valid, that suggests that one of those officers, the one who didn't testify, was misreading them. In addition, Officer Mendez, who testified, said that he suspected that the records were wrong because he believed Mr. KANTE could not have reinstated his license from a suspension within 30 days. He had stopped him 30 days prior for a suspended license, didn't think it was possible Mr. KANTE could have rectified that problem, and believed that the R&B records that his partner said indicated expired had to be wrong. Now, in the 50 minutes he had, 50 minutes he had, plus multiple other officers, cell phones, radio, computer in his car, he and the other officer did nothing to check the R&B records despite having that suspicion. And in fact, they were so sure, or at least Officer Mendez was so sure of the suspension, despite what the R&B records said, that he cited Mr. KANTE for suspension when he arrested him. So for those reasons, that arrest was illegal. They didn't have probable cause. They should have checked with the R&B when they were on notice that there was something about their understanding that was wrong. And had they done so, they would have seen that Mr. KANTE's license was actually valid. And they failed to do that. Now, the second question is, how does this come in as fruit of the poisonous tree if the firearm is found in the wheel well of a car nearby? Well, I would submit to this court that—
Please also address the fact that the gun was abandoned, if you will, placed into onto the outside of a vehicle that was not the defendant's vehicle prior to the arrest as part of your presentation, please.
Yes, absolutely, Your Honor. When it comes to a case like this, where contraband is found in a location other than the defendant's person or their home or their car or something like that, there's two possible routes that you could go down. One is abandonment and reasonable expectation of privacy. Did the individual have a reasonable expectation of privacy in the location where the firearm was found? The defense counsel didn't argue that. I'm not arguing that now. The only other option when that's not available is the fruit of the poisonous tree. And that's where what I'm arguing to this court and asking this court to do is to carefully review the video evidence in this case. Because in addition to Officer Mendez's testimony, where he indicates that he was suspicious that Mr. KANTE bent down by the wheel, but he doesn't say that he suspected he secreted anything in the wheel well, you can actually see the officers responding to the scene, arrest Mr. KANTE, they're feet from the car in the wheel well, and they don't check it. And they in fact walk past that car several times without ever looking at the wheel well. What this shows the court is that the police had no intention of actually searching that area until after they arrested him, found nothing to use against him that was on his person. That's when they went and did these other actions they took. They stopped somebody else, they checked the car, but then they eventually walked that route and found that firearm after doing a careful search. That's where the exploitation comes in and what makes this fruit of the poisonous tree, because the officers would not engage in that action and found that firearm had they not failed to find something on him after an illegal arrest. And the Commonwealth showed no attenuation in this case, Your Honors. There was 26 minutes that passed between the illegal arrest and finding the firearm. That's a very short period of time. In addition, there were no intervening circumstances. There was nothing unrelated to this arrest that caused them to see the firearm. As I said, they walked past that location multiple times without even looking. And then the last factor is purpose or flagrancy in the police action. And here's where I point to the court to—
Let me stop you there. Your time has expired. I will let you finish your thought. Go ahead.
Thank you, Your Honor. I was just going to point the court to the language in Brown that says the arrest, both in design and execution, was investigatory. The detectives embarked upon this expedition in the hope that something might turn up. Thank you, Your Honors. For all other arguments, I would rest on my brief.
Thank you. Let me just see if does the panel have any further questions?
Just one question. I just want to make sure you're not challenging the findings on the motion.
Pardon me. I am challenging the findings because the judge made a clear error about the stipulation in the case. She's believed and wrote in her findings that the Commonwealth had stipulated that the RMV was at fault, when in fact all they stipulated to was that Mr. Kante's license was valid at the time of the arrest. That clear error prevented the judge at the outset from considering all the other evidence that was presented at the suppression hearing.
Okay, so that's the finding that you're challenging.
Yes, I'm challenging that finding. There's also a temporal issue. The judge thinks that the officers found Mr. Kante within a few minutes. That's also clearly erroneous based on the testimony.
Thank you very much. We will now hear from Attorney Lee for the Commonwealth.
Good morning. May it please the court. Mary Lee, Assistant District Attorney for the Bristol District for the Commonwealth. I intended to go in the same order as my sister, if it pleases the court, and start with the Armed Career Criminal Act. My sister cited the Ashford case in her reply brief. I thank her very much for that. That case came out in December after the original briefs had been filed. And Ashford actually provides a very succinct history of this statute and the federal statute and the case law that comes down, and it adds in or clarifies that intentional conduct is necessary, that mere recklessness is not enough. That being the background for it, I'll jump into the argument. In this case, the prior conviction is resisting arrest. Resisting arrest can be proved in one of two ways, one of which is forcible conduct. That throws us into the modified categorical approach. And when you look at the modified categorical approach under Wentworth, which is cited in the Commonwealth's brief, that's an assault and battery case that also has a resisting arrest charge, but they focus on assault and battery. And you look at Ashford, both of those cases say that the Commonwealth can use proof that is beyond what is in the mere records. They can use any evidence that would have been admissible at the trial. And so, and what do we show at the trial? We have to show, in this case, we have to show that it's a violent offense under Chapter 140, which has several prongs. It's the force prong here. So far, so good. I'm pretty much agreeing with my sister on the background of the case law. So the question is, one, can we put in all that other evidence that isn't just what's in the police report? And then two, did we show intentional forcible conduct with that? So I'll jump to the easier one.
So I'm sorry to interrupt, but assuming it was proper to put this testimony in, the question isn't whether the Commonwealth has shown forcible conduct, it's whether the forcible conduct was the basis of the conviction, right? I mean, that's a different question. And so, you know, when you have a recitation of facts at the plea hearing that doesn't mention the use of force, and the police report doesn't mention the use of force, the Commonwealth puts on 2 witnesses, one of whom testifies to force, one of whom doesn't. How is that proof beyond a reasonable doubt?
So that gets us right to the thank you for your question. It crystallizes the exact question here, which I think the best case for the defendant is the Mora case. In Mora, it's the armed robbery case, and that was the ACCA was dismissed because the armed robbery wasn't shown to be a violent offense, the forcible prong of armed robbery at the grand jury. So he wasn't charged with the forcible conduct, and therefore, even though it's armed robbery, it could not be a sufficient predicate offense for ACCA, or I'm sorry, armed career criminal. And so I think Mora is the best case for the defendant in this analysis. And so when you get there, if you're looking at it from that perspective, you would look at the police report, which was offered in evidence in this case, and it has the what was recited at the plea, which is that he ran into traffic. An SUV had to jam on its brakes to avoid hitting him, and the police were chasing him, and that he wasn't obeying their commands, which is not as much evidence as was presented at the trial, at the bifurcated trial in this case. But I would suggest to you that, one, that's not mere recklessness. In Ashford, it talks about reckless conduct with, a domestic violence situation, or reckless driving that ends up in a motor vehicle homicide. And here we actually have intentional conduct. You don't run into the street by accident. You don't run into the street being reckless. You're intentionally doing it. I think you can draw that inference from the police report that accompanied the complaint, the police report having been offered into evidence, saying that's sufficient probable cause to show that he's intentionally using force. What force? The force of the traffic.
I just want, okay, so you're saying even without Officer Reed's testimony about the attempted push, that the other facts establish the use of force? I thought the cases say that this type of resisting arrest falls under the other way of proving that element of the offense, which is the risk of bodily injury.
I would suggest that the information in the police report that accompanied the complaint for resisting arrest was sufficient, unlike Mora, to get us to probable cause of intentional forcible conduct. And if we do, that means we can present all the circumstances of that prong of resisting arrest at the bifurcated trial, which is what we did. Not just be limited to what's offered in the police report. I guess I
go back to my first question, which is the issue is still not whether you could have proved forcible conduct, but whether the actual basis of the conviction was forcible conduct.
And I think for that, that's the Mora analysis. And for that, this is a question that the courts haven't faced before, so you'll have to decide it. But I suggest to you that the evidence in that police report that shows that the defendant intentionally ran into traffic to avoid the police and caused an SUV to jam on its brakes, that's not mere recklessness. That is an intentional attempted, you can use an attempted use of force. It does not have to be actual force, an attempted use of force where people could have gotten substantially injured, not just the defendant, not just the police, but also drivers in the road, that he intentionally was using the force of the traffic to avoid the police, and therefore we sufficiently charged the force prong of resisting arrest. And if we get there, then all of the circumstances of the forcible prong were admissible at the bifurcated trial. And
I understand your argument.
Mhm.
Where I'm having a little bit of difficulty is, and I don't know that our case law has specified this, you're basically taking, not scenario A, but the initial facts that led to, let's call it Officer Reed's testimony, if you will, as to what happened a little bit later. Has our case law talked about the type of nexus that must exist between the initial set of facts and the subsequent set of facts? Do you understand my question? Is not well phrased, but shouldn't there be a nexus there? And when I say nexus, something more than just one followed the other.
I think that Wentworth and Ashford, when they talk about you can put in any evidence that would have been admissible at the trial, So let's assume Mr. Kante had not pled guilty and had gone to trial. All of the evidence that we presented at the bifurcated trial could have been presented against him because we had charged the forcible prong. And that's why we're distinguished from Mora.
Must the actus reus be the same, I guess is what I'm asking, or have a different type of connection?
No, if that were true, then we would have been limited to the paperwork and not all the circumstances. So the language in Wentworth that my sister says is dicta, but also appears in Ashford, would not say we get to put in more than the paperwork or more than what.
I guess when I'm saying actus reus, what I mean is the ultimate. So in other words, if let's say in scenario A, we were talking about not scenario A, but in timeline A, we're talking about the resisting arrest.
Mm-hmm.
But the details weren't sufficient to show the violence or the act necessary to prove armed career criminal.
Mm-hmm.
But then the subsequent details do fill in those gaps. Shouldn't we be talking about the same act as opposed to something that occurred temporarily 10 minutes earlier, or 2 minutes earlier, whatever it may be? I
suggest no, as long as it's properly charged under the forcible prong.
What's your best authority for that proposition?
It's the language in Wentworth and Ashford saying that the Commonwealth can go beyond the record and go to all the circumstances that would have been admissible had the prior conviction go to trial. If this court, I realize.
One more question. What's your best authority for the attempted push, putting the hand out and hitting the officer's hand, qualifying as the use of substantial force?
I think that's the Wentworth case.
Wentworth, okay.
I believe the Wentworth case is the one where there's a slap at the face. I think it's a domestic violence and a push onto the bed. I apologize. It's cited in my brief with that blurb behind it.
Thank you.
So, but I'm not sure if that's Wentworth now that I'm sitting here. I'm sorry.
No, I remember. I know it was in your brief. Thank you.
So if this court disagrees with me and disagrees that we either didn't sufficiently charge it consistently with Mora so that the force prong wasn't properly charged and therefore the defendant wasn't properly convicted under it, then the defendant wins and this goes back for removal of the ACCA and resentencing on the other charges. I'd ask this court to affirm it because we have followed the law that's described in Wentworth and Ashford, and I think we've sufficiently charged it under Mora. Mora just had the statement of the prior conviction and didn't have these additional statements about how the defendant was intentionally running into traffic and using the force of the traffic against him. I realize that this is an unusual fact pattern. I'm asking you to decide something new, as is the defendant. So if there's no more questions on that one, I will move to issue 2 as my sister did. And I would suggest the Supreme Judicial Court in Maloney referenced this statute when talking about statutes being constitutional when they have a permissible rebuttable inference. And I would suggest that this court then, and that's also in Grant in my brief, and then this court in Ferrer in a published decision on this statute relied on Maloney. So this statute's constitutional. The SJC has said so. I'm bound by it, as we all are. And the instruction was consistent with the statute and with Ferrer, and so therefore that was correct. But my sister, I think, I don't want to speak for her, but what I understand she's saying is this case is different because this gun didn't have an obvious scratched out serial number. However, even when you have a gun with a scratched out serial number, that doesn't mean that the person possessing the gun knows what that serial number was or that it was even a serial number. Scratching out sections on a gun doesn't necessarily tip someone off to the law. So that's why it's a rebuttable, permissible inference as stated in the statute. And the defendant at trial argued this to the jury, saying that inference simply, you're going to hear about the inference, that's not enough. This gun could have been placed there by anybody, and the inference that he knew about the missing serial number was not enough, and the jury found otherwise. there was no rebutting to this permissible inference, and I would suggest this case is no different. It cannot be meaningfully distinguished from Ferrer, and I would ask the court to affirm that conviction. If there's no other questions on that, I will move quickly to the motion to suppress. It's Commonwealth's position that the defendant did not properly raise fruit of the poisonous tree. I provided their motion to suppress in my addendum. It doesn't cite Wang Sun, which is the case that everybody says with fruit of the poison tree. It doesn't say fruit of the poisonous tree. There are no findings about fruit of the poisonous tree. And so under MUBD, that's not properly preserved and properly waived. And this court could make that determination on this issue, on that charge, on that basis alone. I agree with my sister. When you have fruit of the poisonous tree, you don't have to show a reasonable expectation of privacy. And that's because the police unlawfully stop somebody and he says, okay, you got me. Now I'm unlawfully stopped and arrested. The gun is in the wheel well of that truck over there. That's why under fruit of the poisonous tree, you don't need a reasonable expectation of privacy in the wheel well of the truck over there, because your privacy has already been stopped by the police unlawfully. But here, they didn't get any evidence. They didn't get a statement. They didn't get anything indicating where the gun was. They got nothing, as my sister stated in her argument and in her brief. So, and the police had seen him kneel down next to the car prior to any allegedly unlawful conduct. And so that's why fruit of the poisonous tree doesn't work here. The defendant did not have a reasonable expectation of privacy in the wheel well of a truck, because nobody has a reasonable expectation of privacy there.
What about the argument that they only looked in the wheel well once they didn't find anything on his person? How do you respond to that?
I would suggest that's a very different view of what fruit of the poisonous tree is, because their observations of the defendant occurred prior to any stop, and therefore it's attenuated. And I cited the Frederick case from the Supreme Judicial Court on the issue of attenuation, but this is not a fruit. This finding of the gun did not come from the stop or the search or anything else to do with the defendant. It came from the police observations when they had not yet exerted any force on him. I see my time is running out, so I'm happy to answer any other questions. I would ask this court to affirm the defendant's convictions on all charges.
And seeing no further.
And we are back live and on the record.
Good morning. Calling our next case on the list, docket number 2019 P0512, Commonwealth versus Bishop. We will hear first from counsel for the appellant, Attorney Griffin.
Good morning, Your Honors. May it please the court. My name is Geraldine Griffin. I represent Mr. Bishop. There are a number of issues raised in the brief, Your Honors, but I'm just going to focus on two. The first being the admission of the opinion evidence from the EMT that arrived on the scene, and the second being the admission of the defendant's roadside statements despite the absence of a hearing on voluntariness. With respect to the EMT's testimony, Your Honor, just a few things I just wanted to point out. On appeal, the Commonwealth basically agrees, it's in note 17, footnote 17 of their brief, that the witness gave opinion evidence, medical opinion testimony in this case. And therefore, the Commonwealth would like this court to view the EMT, Mr. Morrison, as an expert witness. The defendant's position is that he was actually a lay witness. And because he was a lay witness, the medical opinion was improper. If you look at Commonwealth versus Wolcott, which is cited in my brief, it talks about that on appeal, a witness has to be treated as they were below, as the prosecution presented them below. So if the witness was presented as a lay witness below, they have to be treated as a lay witness on appeal. The prosecution, and the Commonwealth in this case, is really trying to have it both ways. They presented him as a lay witness below, and now they want this court to analyze him as if he was an expert. So I just wanted to point out a few things in the record that support the defendant's assertion that he was actually presented as a lay witness. First of all, most importantly, the prosecutor herself asked Mr. Morrison on redirect, it's on, I believe, page 53 of the second volume of the transcript, whether he was an expert on seizures. And he said, no, I'm not. So right there, you have the Commonwealth below bringing out the evidence that this is actually not an expert. Secondly, if you look at when the prosecutor was asking the initial questions of the witness when he took the stand, she asked a few questions about his qualifications, but they were pretty minimal. It kind of reminded me of when basically anytime a prosecutor calls a law enforcement officer to the stand, they ask a few questions, even if they're not going to testify as an expert. You know, how long have you been an officer? Have you been to training? What's your education? It was those were the kinds of questions that they were asking the EMT. So just, have you been to training? How many hours of training? Have you ever seen anyone in a seizure? But notably, she didn't ask, number one, how many years have you been an EMT? I suppose you could infer it based on the fact that he did his training in 2007, but she never said, how many years have you been an EMT? She never asked him, how many seizures have you seen? She just said, have you seen any? And he said, yeah, I've seen people. But nothing that you would expect if you're going to ask someone their medical opinion about whether the defendant was seizing or was in the later stage of a seizure, and ask them general questions about, to tell the jury medical information about seizures, you would expect the prosecutor ask a lot more qualifying questions.
Was there an objection on the basis of a lack of foundation for the?
Yeah, well, what happened, Your Honor, is basically, from my reading of the transcript, is I think that the defense attorney, based on the questions that were being asked, I think the defense attorney thought this was an expert witness.
All right, but you still have to answer my question.
Yes, I do. Yeah, but I think if you look at the chronology, it helps. So I think what happened was on redirect, when she says, oh, I just want to clarify, you're not an expert on witnesses, that's when the defendant objected. And he's sort of like, whoa, what's going on here? And I agree, it's not super articulate in the transcript, but he did say, based on what he just said, it seems like it eviscerated, the language used, it eviscerated any foundation for those kinds of opinions. And I agree, that's the extent of the objection.
Okay. Let's assume it's sufficient. How do you show prejudice on this record? I mean, it seems to me, had there been a motion for new trial, you could have introduced, for example, an expert who could have said, this is entirely consistent with, his behavior was entirely consistent with seizures, and the EMT was wrong. Absent that sort of testimony or that sort of basis, how do we discern prejudice on this record?
Well, because this was the only medical testimony that was admitted at trial. So this is the only, besides the defendant's medical records, this is the only person in the medical profession that testified.
But you don't seem to be challenging the content or the accuracy of the testimony. So how is it prejudicial if it's accurate, at least on this record?
Well, because there's a reason why lay witnesses aren't permitted to give opinions about specialized knowledge, because the jury is likely to credit it.
But counsel, in this case, wasn't it made abundantly clear that he was speaking only from his experience as an EMT, his observations of other people, but that he had no specific expertise, and he wasn't giving a medical opinion? Wasn't that made abundantly clear to the jury? He wasn't giving a medical opinion.
Well, he himself couches everything as, I'm not an expert, but I don't think that you can analyze testimony that way, because it's either lay testimony or it's expert testimony. There's not,
well, you made the analogy before to police officer testimony, which I thought was very apt. If a police officer testifies about their experience with having seen people who are under the influence of drugs, they can testify to those things, but they're not necessarily an expert in pharmacology, or cannot give necessarily an opinion regarding what that person is actually going through.
Well, that's true, but that's a different situation. So the case law does say that if it's a medical condition that is within the common experience. So for example, a lay witness can testify that someone seems to be intoxicated. And I would assume drugs would be the same kind of thing. The person seems to be under the influence of something. That's perfectly okay, but that's not what happened here. This is way outside the common understanding or knowledge of a lay juror. So it's completely outside of that. It's very distinguishable from an officer saying that someone was under the influence of drugs.
There was other testimony regarding the actually the defendant presented testimony. Is that correct, regarding the defendant's appearance when he may have a seizure? So
yes,
that
yes.
was in front of the jury.
Yes, there were two, his son and his former girlfriend both testified that they had witnessed him on a couple of occasions having a seizure, just on a couple of occasions. That's true. But I don't think that takes away from, you know, if you're talking about a jury and this is the only medical testimony that they're getting, and not only that, this is a percipient witness. So you have that issue too, where, you know, the case law says you really shouldn't have a percipient witness testifying to this sort of specialized knowledge at the same time. Even if you do consider him to be an expert, that's problematic because the jury is more likely to credit that or give more weight to that testimony. The other thing I just want to point out in terms of him being presented.
The EMT's testimony, his description of what happens during a seizure and what happens after, would you agree that it was largely consistent with the defense witness's description of what happens when this defendant has suffered seizures?
To a degree, yeah, it was.
And isn't, you know, if the jury accepts all of that testimony, wasn't it pretty much irreconcilable with how he was behaving on that day? So, and if that's the case, then how was there prejudice?
I mean, I understand your point. I just think if you have this, again, I don't want to, you know, be repeating myself, but if you have this, the only medical witness who's also the person who saw him at the scene saying, well, this is what seizures are like, and I didn't see him, he didn't look like he had just had a seizure. That's very strong evidence for the jury, and they're going to give that a lot of weight if that's all that they're hearing from a medical, so, you know, supposedly maybe an expert. But I just wanted to get also to what the judge said after the defendant objected, because I think that's kind of telling as well as with regard to whether this was being presented as a lay person, a lay witness or an expert witness. She says, it's on page 54 of the second volume, after he's objected to the testimony, she says, well, he's not a doctor. And just the fact that he's testifying based on what he's observed in his experiences and training, and he testified he had some training. So my interpretation from that is that she thinks he's a lay witness as well. I mean, if she thought that he was being offered as an expert, you would think right there she would have said, you know, Madam Prosecutor, are you offering this person as an expert? I'll make a finding. I'll qualify him or I won't qualify him. But she didn't do that. So the Commonwealth on appeal is trying to say there's this like implicit qualification. She had the opportunity. It's not like there was nothing was ever said about it. And you could say, oh, well, it's implied. The judge had the opportunity on page 54 to do that, and she didn't do it. So I think that's telling as well. And then, of course, the fact that there's no instruction. And the last thing is if you look at the prosecution.
Instruction requested?
No, it wasn't. The last thing is if you look at the prosecutor's closing, the only time she mentions this topic, it's on page 42. I think it's in the third volume. She just says, the EMT saw no evidence, according to what he's seen in his experience, that he was having a seizure. So all along, she is presenting this person as a lay witness. And my point is, under Walcott, you have to treat the witness as a lay witness if that's how the Commonwealth presented them below.
Which part of the testimony are you challenging precisely? Could the EMT have testified as a lay witness that he was called to the scene and he assessed the defendant and determined that he wasn't having a seizure, didn't have a seizure based on his his training and experience, would that have been proper?
No, I don't think so, Your Honor, because all of the case law says that a lay witness can't testify to the medical condition of another person unless they've been qualified by the judge, you know, and the foundation has been laid. So no, I don't think he could have said that. He could testify as a lay person to his observations and, you know, if they were admissible, what statements were made to him, if, you know, if it was for medical treatment. But unless he's qualified as an expert, he cannot give his medical opinion.
So could they have asked basically for the EMT to relay his observations? And well, let me strike that. Could they have asked the EMT, were you trained as to what the symptoms of seizures are? And then have the EMT testify to the conduct of the defendant that he observed. And then ask the question, did you see X? Did you see Y? Did you see Z? In reference to the EMT's earlier testimony regarding seizure symptoms.
I think in that situation, you would still have to lay a foundation because he's giving a medical opinion. And that's what the Commonwealth typically does. You know, I'm not saying if the Commonwealth, you know, had made an effort to lay more of a foundation, maybe they would have succeeded, but it's not on the record.
Does the same apply to the defendant's witnesses? Do they need to be qualified as experts in order to provide their testimony regarding what happens when a seizure occurs with this person?
I guess so. I mean, his witnesses didn't do that. All they said was, this is what he looked like. This is what he sounded like. You know, and they're not presented to the jury. They're not presented to the jury as a medical.
I'm sorry to interrupt you, but didn't they? That's okay. Didn't they testify to what he looked like, sounded like, and appeared like when he had seizures?
Yeah, but I'm saying that the impact is different because even if you say that's not okay, the impact is different because they're not medical professionals. This is an EMT. So the jury's trying to figure out, was he drunk or did he have a seizure? Who are they going to listen to more than the medical professional that was on the scene? I'm about to run out of time. I just want to say with regard to the involuntariness of the statements and the lack of a voir dire, the cases that the Commonwealth cites, a few of them, they're very distinguishable because in those cases, for the most part, there was an express waiver of a hearing and even a colloquy in some of them of the defendant before they did not, you know, before they waived the hearing for the involuntariness of the statements. So I just say that's not present in this case at all. And in those cases, you had a correct humane practice instruction where here you did not. So if there are no further questions, I'll rest on my brief for the remainder.
Well, your time has expired, but I have one question on the voluntariness.
Sure.
Are you suggesting that the statements would be involuntary or might be involuntary on the basis of intoxication, or might be involuntary on the basis of the seizure, or both?
Could be both. Could be both. And I agree, if it went to the jury and the jury determined that they were involuntary because of intoxication, it would be a moot point. But that's not what happened. It never even went before the judge. And that's what should have happened before it was presented to the jury.
Let me just check with the panel. Any further questions? Well, thank you for your argument and your excellent knowledge of the record in this case.
Thank you.
We will now hear from the counsel.
Thank you very much. May it please the court, Kenneth Steinfeld for the Commonwealth. I take a fundamentally different view of the testimony by the EMT in this case, which was presented solely and entirely as expert testimony. It was never presented by the Commonwealth as lay opinion testimony at all, because it is not within the standard understanding of the average human being what the signs and symptoms of a seizure are, how long it lasts, the post-ictal period, what happens during that period. This was solely presented as an expert witness. I don't think lay opinion has anything to do with this case. It was established through his experience and his training that he had seen people suffering seizures, and he had seen them during their postictal periods, and that based on that experience and his training, he could say that what he saw that night was not consistent with those factors. He never said, in my opinion, he had not suffered a seizure. He was asked on cross, well, do you know whether he suffered a seizure? And the answer is no. All he was saying, based on his training and experience, was that what he saw was not consistent. And as Justice Neyman has pointed out, if the son and ex-girlfriend of the defendant are able to testify what happens when he has a seizure with no medical training at all, then someone who has years of experience as a paramedic, as an EMT, who has seen things and been trained in them, certainly may opine as to what factors are ordinarily associated with a seizure, none of which was apparent on this night.
But the Commonwealth didn't present him as an expert, and the judge didn't qualify him as an expert, right?
Well, but it did present him implicitly as an expert by the form of questions that were asked of him. If you have a lay opinion, say about intoxication, you don't ask, well, how many people have you ever seen who are drunk? When was that? You know, over how many years, how many people? You just ask, and did the person appear intoxicated? That's a lay opinion.
Isn't your sister right that Wolcott says that we can't just assume that the judge silently and implicitly qualified him as an expert, where he wasn't presented that way and there was no instruction given about expert testimony?
Well, there are a bunch of cases that I cited in my brief that a judge may implicitly qualify him. And here there was no objection at all to his testimony. To his testimony. If there had been, then of course any of these foundational requirements might have been satisfied if they were not satisfied in the first place. But the lack of an objection deprived the Commonwealth of an opportunity to do that. And
how do you interpret the judge's comments when an objection was made?
Well, she said, why are you raising this now? You had no objection earlier when this was presented. And the sole basis of the objection at the time following redirect was, he's not a doctor, he's not a neurologist, he's telling you that. So defense counsel was saying that in order for him to give the expert testimony that he was giving, he had to be a doctor or a neurologist. And the judge basically did not address that. She said, well, nothing has come out since his direct and since his cross that you didn't already know, and you failed to object to it. So I'm going to deny it. But I think it was plain both that the testimony was offered as an expert and that the objection came way, way too late.
What about the absence of the jury instruction regarding expert testimony?
Well,
putting aside that one wasn't requested.
Right. That instruction would not have added a whole lot to the standard instruction. And there are cases that say that its absence is not a substantial risk of a likelihood of justice when a jury receives a full and complete instruction on how to judge and assess the credibility of witnesses generally. Sure, they'd have been told that this is an expert witness and you should not exalt his testimony. You are the sole finders of the fact. Here, I think the defense got a break in a way that he was not presented as an expert. And there are two cases that I cite for this proposition, that it is less prejudicial if the person who testifies as an expert has also testified as a recipient witness. Had the judge said in front of the jury, he has been designated as an expert and therefore A, B, and C, then there would have been a greater possibility the jury would have delegated to the expert the right to find the facts. And here, the fact that they didn't do that makes it much less likely that they were so impressed by his status as an expert that they abdicated their responsibility to act as the finders of fact.
So though he was an expert witness, the fact that he was an expert wasn't highlighted to the jury. Is that what you're saying?
Yes, and I think that that benefited the defendant. He was just like any other witness, who also happened to have this expertise, and he was able to testify what the symptoms of a symptom. I'm sorry, the symptoms of a seizure and what happens in the aftermath of a seizure, without the jury being told this guy is special, so you have to listen to him, or to pay extra careful attention to him.
Did I hear you say that it would be less prejudicial for a percipient witness to also testify as an expert?
Yes.
Isn't
And
isn't it the opposite, that it's more prejudicial for the percipient witness to be giving expert testimony?
Well, I think it's not, because he isn't designated as an expert. And I
But
cite,
you're saying that the testimony he gave was expert testimony, and he was also the percipient witness. And so ideally, I would think the Commonwealth would present him as the percipient witness and then put a medical expert on the stand who could testify as to the symptoms of the seizure disorder.
well, there are cases in which officers have testified as to narcotics who's suffering an overdose, and they've also been the recipient investigating officer. And I don't have the citations to hand, but it actually says in those SJC cases, this is better for the defendant, that he's just a percipient witness, and he has not been designated as an expert. And I'd be happy to.
So long as he's testifying solely as a percipient witness, but you're saying that the EMT was testifying both as a percipient witness and as an expert witness.
Yes, that's right. So
and that's where the prejudice
jury would have,
right?
I'm sorry.
That's where the prejudice comes in. The cases that you're talking about say that the prejudice is lessened because they're putting these officers on the stand just solely to testify as percipient witnesses.
No, I'm saying there is less prejudice from any error in their testifying as an expert if they also testify as a recipient witness without any special designation by the court as an expert. So when the judge instructed the jury how to assess the credibility, they'll apply that entirely to all of his testimony, both as a recipient witness and as an expert. So I'm not sure if that satisfactorily answers the question, Justice.
I think I understand what you're saying.
That's my argument, at least. And certainly, if you don't agree, then that's your prerogative, obviously.
I have a few questions on the voluntariness issue.
Certainly.
First one is, would the trial judge have erred in conducting a voir dire sua sponte on voluntariness here?
Absolutely not.
Okay. I've seen the OUI context is interesting when it comes to humane practice.
It is very interesting. I agree.
Have we ever, has our court or the SJC ever had a discussion of sort of the unique qualities of voluntariness and humane practice in the context of OUI cases?
No, it definitely has not. And there's an irony there, because if it's found involuntary, then the jury is instructed to ignore it entirely. If the jury were to find that he was too intoxicated to have made the statements in the case in which he's charged with operating under the influence, then there's, I don't know if that's a double-edged sword or there's something not exactly right there, but I found nothing. And I looked for that very issue to see if this, I don't know if it's a dichotomy, but it's an oddness that this is the cases that hinge on the intoxication of the defendant are an odd fit for voluntariness.
Right.
And as my sister said, here it's based on both or either a seizure or alcohol intoxication. Had the instruction been given, that instruction includes if you find because of his alcohol intoxication, which of course would not have done the defendant any good. And a reasonable counsel might have thought, gee, better not have that instruction, have that language in that instruction, because that draws the jury's attention to the fact that they could exclude his statements because he's intoxicated. But the fundamental point remains that these statements were essential to his defense. And without them, he had almost nothing. And there was a lot of other evidence besides those statements. So there's just no way around that the entire case was built on, from opening statement through cross-examination, through closing argument, to the weird conduct, which he said was based on the seizure. And that included both the nature of his speech and the content of his speech. So it certainly would have been, or was, a reasonable tactical decision not to object to that. And also, there are several cases in which the SAC said that's true, Zagrodny and Leroy, and yet they put the voluntariness question to the jury as well. And basically, the jury had everything before it that it needed to decide the case. They had the instruction, and they had the defendant's statements, which they could have used either to find that he was intoxicated or to find, as the defendant asked him repeatedly, that he had had a seizure.
Yeah, and one of my concerns is that some judges will give a humane practice voir dire and instruction in every OUI case. Others won't unless it's raised by defense counsel. I think there's a lot of inconsistency in the courts, as you say, because of sort of the oddity of this issue in the context of an OUI case, or I should say the potential oddity.
Right, it exists, and here the defense counsel used an interesting word. He said that the voluntariness issue dovetailed with his defense. And I know what he meant by that. They both go to his state of mind. But as I said, if he succeeds on voluntariness grounds, all those statements cannot be used by the jury for any purpose at all. And that takes away his defense in large part. And as has been pointed out, none of his conduct that evening was consistent with the testimony either of the two defense witnesses, his son and his ex-girlfriend, or the EMT. It just didn't match up. The defense lawyer in his closing sought to match them up, but as the prosecutor said in her closing, it just didn't jive. And that's because of the strength of the evidence that he was intoxicated and that he had not suffered a seizure. Now, if the members of the panel have no further questions on that, I'd just like to say briefly about the photograph, the booking photograph. I had intended to and thought I had submitted a color copy of that photograph. And I also thought that I had filed a motion to have it sent from the
We have that.
There's a copy in the record appendix. Page 23 of the record appendix is a color photo of the booking photograph.
Oh,
Exhibit 2 at trial.
I see. I've been working off of a hard copy of the brief, which was printed out from that. And so I thought it was black and white. Okay, then in that case, forget about that. I think that image obviously depicts a drunken man, or at least the jurors could have so found. I think if you were to show that picture to 100 citizens of Essex County, or to Russians or Latvians or Finns or Mexicans or Paraguayans, 90% of them are going to say, that guy looks drunk to me. And I think it was certainly very, very strong evidence. And I find it helpful. I cite a case from the Texas Court of Appeals, Bearfield, which said a photograph is competent evidence of any subject about which a witness's description is proper. And I think that states the law of the Commonwealth, but it has not been so clearly stated. And so I would ask this court that if it talks about this subject, that it point out that any time that a photograph is competent, anytime that a verbal description of an item is competent, then a photograph or a video of that same item should also be competent evidence. And I cite that Bearfield case on page 56 of my brief.
On the OAS, you are in agreement that it's a lesser included, and the remedy is that the lesser included is dismissed. Is that correct?
Yes, I am. The indictment is, I saw that the cases say that the conviction shall be dismissed. And I'm not sure really what that means. And so I included, I said, I think the indictment should be dismissed. If there's something, if a conviction can be dismissed, then it should be, but I said the indictment itself. And so, yes, I totally agree that he can't be sentenced on it. And although it was placed on file, he's entitled to have it dismissed.
So the fact that he was charged with a subsequent offense doesn't make a difference because
that's correct. And during the, I see my time has expired, so I will.
You can answer the question.
I'll speed this up. At the subsequent offense trial, which was a bench trial, the judge only addressed the prior convictions for OUI, never addressed the prior conviction for OAS. So it was not a subject at all that was dealt with. The subsequent offense aspect of the OAS was not an issue. And I agree that it should be dismissed. And if the court has no further questions, I'm happy to rest on my brief.
We'll proceed. Thank you.
And we are back live and on the record.
Good morning. Calling our third case on the list, RUBIN versus RUBIN, docket 2018 P1654. We will hear first from counsel for the appellant, Attorney Rosnoff.
Thank you. May it please the court, Attorney Elena Rosnoff for Eric Rubin. Your Honors, the matters before the court this morning and the focus of this appeal are whether the findings and rulings of the trial judge when she made the determination that the party's business be sold was an error, and whether or not the alimony award in light of the totality of the circumstances presented to her was excessive. With regard to the sale of the business, Your Honor, the appellant is not disputing that the judge has wide discretion when fashioning a division of the assets and whether certain marital assets should be sold. However, in this case, the asset in question is the Rubin Thompson home, which is an assisted living. It was a sole proprietorship that turned LLC at some point during the marriage and increased from 2 beds to 10 beds. The business was—
Let me stop you right. I have a preliminary question.
Sure.
As I understand your argument, you're saying that the judge erred in requiring the sale of the asset, and at least one of the central reasons is because you're suggesting that the judge double dipped. In other words, the judge should not have counted his salary and the funds that he received from running that or operating that business when the business was required to be sold. Is that correct?
That is correct. That is in part correct.
Had the judge, assuming you're correct on the double dipping, we'll explore that. Had the judge not counted it twice, did she still err by requiring the sale of the business?
I would suggest that she did, Your Honor, because the business was really the sole asset of the parties. Once she awarded the wife the marital home, she made a further decision that the wife, due to illnesses that the judge credited that she suffered during the marriage, as well as the fact that she didn't work and was solely responsible for supporting those children, created a lifestyle for these parties that Mr. Rubin would not be able to sustain without income that would have been generated from a combination of his job at NECO that he was holding, plus the income that he was able to generate from the sale of the business. The trial judge did consider that obviously a sale of the business would result in a loss of income to Mr. Rubin, but didn't go beyond that in making a determination that the wife and the children would be in any less need of the amount of support. I'm sorry.
Putting aside the issue of income,
yes.
What was the error committed by the judge in ordering the parties to sell this business and divide the proceeds?
That she didn't consider its value first, not only just the income to Mr. Rubin, but what the actual value of the business was.
Are you saying that the judge was wrong not to credit the husband's testimony regarding the comparable businesses? Is that your argument?
In part, I am saying
so
that.
How do we review that? Well, first of all, given that's credibility determination, but also we don't have the trial transcript.
Oh, I apologize. I can get those up to you.
Well, were the transcripts ordered?
Yes. Yes, I have the transcripts. Yes.
Okay, because they were not filed with us.
I can certainly do that.
Okay.
We will discuss that and
okay.
issue an order one way or another with regard to that. But as of right now, they're not part of the record before us.
Okay. And I apologize because Mr. Rubin did file pro se the notice of appeal and did the ordering of the transcript. So I apologize for that. And I will, whatever the court would like me to do with that.
Going back to the issue though, my understanding is neither party had an expert valuation of the business submitted as an exhibit or introduced evidence of an expert valuation, correct?
That's correct. However,
and let me go further. My understanding is that there was evidence that the husband filed a financial statement valuing it, I want to say around $700,000, but there was testimony or evidence submitted by the wife that he had valued for other purposes at $5 million or $7 million. Am I correct about that?
You are correct about that as well.
So here's my question. With all of that background in mind, how can it be said that the judge erred in this instance then in deciding that a sale was appropriate? Again, when there was really no other information before her, or at least no information that she credited that allowed her to determine exactly what the asset was worth.
Correct. So what had happened, Your Honor, is the wife had presented evidence that he had valued that business when he was attempting to get a loan, and on loan applications and credit card applications, and whether he inflated the value of the business to do that is unknown. The wife did not ever put forth a value of the business. The parties actually, and the judge in her findings, did make reference that there was a forensic accountant that was hired. The husband paid for that forensic accountant. However, no valuation was completed because the wife failed to cooperate. So we have then the husband at the time of trial valuing, truly giving his opinion of a value of the business and showing the judge what the comparable businesses were. This assisted living, as Mr. Rubin tried to explain to the judge, this is not a facility that is a commercial looking facility. This is a home in a residential neighborhood. So when valuing whether the business is worth anything, it's really what the property is worth, and whether or not there's residents. The judge, it was difficult to read, and as the court is aware, due to the docket in this case, the parties are in litigation in the lower court over the business. There was post this trial a true expert valuation of this business done, and for what it's worth, it turns out the husband wasn't off in his value. But I understand we're before the court with what was before the trial judge. Unfortunately, there was enough my argument is that there was enough information brought before the trial judge, even if she discredited 100% of the husband's a testimony about the comparative properties that he was giving. She didn't have any evidence to the contrary, but she also had the returns and the debts of the business, which she saw and had. She made a finding, or in her finding, she made a statement that the business had unpaid taxes in 1 year of $356,000 or so. So she had numbers in front of her that if she applied a valuation, she could have attributed a value to that business and then, you know, didn't have to order it sold. So the fact that she didn't take that step, especially, and I hate to conflate the arguments, but unfortunately, you know, they do go hand in hand in this case. You know, she made this determination to sell this business that had this value, but couldn't determine the value, but then in the next instance said, well, it's at least worth $400,000 a year in income to the husband, so that's what we're going to use to determine.
Well, those are different issues, right? The value of a business versus imputed income. I mean, we know what his reported income was. She's imputing additional income because he's, you know, maybe doing some things that weren't appropriate. And so those are two different issues. So she could find one, the evidence to be speculative as to one, but not the other.
She could. However, in her determination, you know, when she decided that she couldn't, quote, value this business and didn't know what it was going to sell for, she still assigned Ms. Rubin $144,000 off the top of the sale of the business. So does that then should that then have been taken off of the income that she was using to determine his alimony amount? I mean, it was really just.
Right, so getting to the alimony, I mean, you call it double dipping. I see it as a little different because double dipping would apply had the judge actually assigned the asset to the husband and then also included the income derived from that asset in the alimony calculation. That's not what happened here, right? So she's saying, you know, at some future date, this property is going to be sold. And at that point, the proceeds will be divided. And she calculates alimony based on the income that he's earning. Now, until the property is sold, he's still earning that income, right?
Ideally, but he's taking advances on a business that isn't a true salary.
But assuming the judge's findings are not clearly erroneous, he's still earning income from the business until the point when it's sold, right? So it's not a double dipping issue. So why can't we read, so the judge expressly acknowledges that once the business is sold, he's going to lose that income. Yes. So why can't we read the decision to be saying that until the business is sold, this is the income that I'm imputing to you. And at that point, I acknowledge there will be a change in circumstances once the business is sold.
It could be read that way, but unfortunately in this situation, as I stated, it's not necessarily a separate issue, right? Because she's said that the wife is entitled to $144,000 out of this business for some reason. So as I stated, shouldn't that have been taken into consideration that he can't necessarily take that as income? Or
not until the property is sold. Right. You have the income that he's earning, an actual income. It's not attributed. It's an actual income that he's going to be earning until the property is sold.
So
right?
I don't know. So the only actual income that he had was from his job at NECO. The income, the problem was that it wasn't an income to him like he was taking a paycheck. Those advances on his financial statement, the $7,000 that he was advancing himself, was to pay for all of the court-ordered expenses under the temporary orders. He was instructed to pay the child support in the amount of $1,000 a week at that time. There was no alimony payment at that time. He was instructed to pay the mortgage on the marital home, which was $3,500 a month, plus keep up all of the business expenses. So what he did was he took those advances from the business. He didn't take a salary. He advanced what was necessary to keep up with the credit cards, the mortgage payment.
Okay, I mean, so that's a different issue. I mean, you're arguing that as a factual matter, the judge erred in coming up with the imputed income. I'm asking a different question, which is, what you're calling double dipping, and I'm calling something different,
Yeah.
which is, why is it double dipping, or whatever you want to call it? Why is it counting something twice when the judge is acknowledging that when the business is sold, he's not going to be earning this income anymore? So at that point, he could come in and seek a modification.
If the court looks at it that way, that would be the proper proper remedy. I apologize. That would be. If the court,
has the business been sold yet?
no, it's there's been a stay of the sale of the business pending the appeal, because obviously if we put forth the sale of the business and the appeal is successful, we couldn't get the business back. So it's been stayed. At this point, it's been valued. At
Have
this
the
point,
parties been talking? I mean, it seems like it would be in the parties' interest, perhaps, for this business not to be sold. And the parties would certainly be free to keep talking about it.
I can tell the court that has been a subject at the lower court. We've been sent to conciliation. An expert has come in, one of the leading experts in the industry of selling these kinds of business, and he's valued the business. I'm up against an appellee who is
we can leave it at, I'm sorry, we can leave it at that.
Okay.
There are obvious reasons for the parties to possibly continue a discussion.
Right. And I hope to do that.
That point should be well taken by both parties, but otherwise, why don't you, you have 26 seconds left. So why don't you put your argument?
Thank you, Your Honors. I would, given that this is the sole source of income for the business, I believe that, you know, that at a minimum, the issues need to go back before the trial judge. And this should be remanded to be able to determine a value of the business. And also, if there is a good and real value of the business, whether it needs to be sold or not, you know, can be reestablished, and also his income. I see I'm out of time.
Any further questions from the panel? No, seeing none, thank you for your argument, your helpful briefing. And
thank you.
I will check with the panel to see if there are any questions for Attorney Gallant, counsel for the appellee.
Thank you.
I have a question, counsel.
Yes.
Given the judge's acknowledgement that when this business is sold, that the husband is not going to be earning this income anymore, how is it proper to fashion an alimony award that continues to include that income indefinitely?
Well, she didn't. Actually, she made a specific finding that this income will cease upon the sale of the business, but then she went further and made specific factual findings in the record about husband's background, his experience, his licenses, and his history over a decade of earning income similar to what he was pulling from the Rubin house, which is the asset in question. She specifically made findings in paragraph 185 that the husband has the ability to acquire future income from other employment, that he's maintained 2 jobs during the course of the marriage for over 10 years, and has the ability to earn similar incomes that she declared in this case, even after the sale of this business. So she made specific findings that the husband, who has a background in paragraphs 100 through 103, she specifically made findings of the husband's background as an engineer and his certificates in HVAC, his certificates in oil burning.
So you're saying that the judge, we can read the judge's decision to attribute income to him at the point that the business, after the business is sold? That's what you're saying?
I'm saying the judge made specific alternative findings about the husband's ability to earn an income and his ability to earn income similar to what she attributed to him from the Rubin house. And
right. So I mean, what you're saying is that we would have to read the decision to mean that I'm imputing this income from Rubin Thompson to the husband until the point the business is sold. And then after that point, I'm attributing to you the same amount of income based on my assessment of your ability to his background, et cetera.
Exactly. Right? I think that's part of the answer.
But nowhere in the rationale does she say the word attribution, as far as I could tell.
Well, she doesn't need to. I mean, she doesn't say attribution. What she says is the husband specifically has the ability to earn income similar based upon his experience and his qualifications and his experience and his licenses. And what she says further is that, again, this is an alimony award, which can be modifiable, which has been modified. In 2020, the husband has modified this alimony from $1,500 down to $925.
So
based
when
upon
the property is sold,
yes,
when the property is sold, he's going to lose that income.
yes.
Then what happens?
Well, then the husband has an ability to go back to the probate court to seek a modification of the alimony.
So why is it his burden to come in and seek a modification when we already know that once that business is sold, he is not earning that income anymore? No matter what, he's not going to be earning the same income. So why is the judge, when she expressly acknowledges that fact, putting the burden on him to come in and seek a modification?
Well, because she made specific findings that throughout the course of the marriage, even before they acquired this asset, this RUBIN house asset, this assisted listing asset, that the husband has been able to maintain similar income in order to maintain their upper class lifestyle during the course of the marriage. He's an engineer that also holds 5 to 6 other licenses and certificates, has been unable to maintain 2 jobs throughout that period. So the husband, even without this RUBIN house income, has the ability to earn this income. And that's the finding she made for purposes of determining an award.
I understand what you're saying. Thank you.
Thank you.
Any further questions for Attorney Gallant? Seeing none.
Elizabeth Schlein and I are appearing pro se. Our home at 70 Dane Street directly abuts the lodging house at 68 Dane Street, historically known as the Graycroft. We've lived here for more than 34 years. A site plan showing the relationship of our home and 68 Dane Street is at page 298 of the record appendix. This appeal relates to the special permit granted by the Beverly Zoning Board of Appeal to convert the non-conforming lodging house known as the Graycroft to another non-conforming use, a 6-unit condominium with 2 or 3 bedrooms per unit, a total of 13 bedrooms. The issues in this case concern the proposed parking layout shown on the plan at record appendix page 288. As the court has seen, the plan calls for 6 parking spaces, nose to tail, along our entire 111-foot common boundary. The trial court found, after review, that the parking spaces even encroach into the public sidewalk. The court also found in its findings of fact that the 6 spaces did not fit and that one of the spaces could not be used as by a vehicle if the adjacent space was occupied. In fact, she ordered the appellee that if it advertised the spaces, it had to advertise the limitations on those spaces. There is also evidence in the ZBA's decision at record appendix 20 that the board was told by counsel to the proponent that the paved parking was already in existence at the time of the hearing. The board also accepted counsel's representation without any backup that there was room to parallel park. The parking layout, in fact, requires paving over the grassed area in the backyard, and the record shows that there is not room to parallel park. There's a photo of the existing parking, which consists of 2 tandem parking spaces at record appendix 316. As the court is aware, Chapter 48, Section 6 permits a change in a non-conforming use if there is a finding by the special permit granting authority that the extension or alteration shall not be substantially more detrimental than the existing non-conforming use to the neighborhood. However, the changes in use and the changes in dimensional and parking requirements are treated separately by the statute. The ZBA in this case has conflated the parking and the use and determined that the entire bundle is not more detrimental to the neighborhood. It is our position that the ZBA is not allowed to permit, in essence, dimensional or parking variances simply because it has made the required finding that the use is not more detrimental to the neighborhood.
Mr. Schlein, may I interrupt you there and ask about a specific provision, section 85, which has been referenced, regarding specifically regarding non-conforming parking.
That section does permit the ZBA to waive the parking requirements, but 68 Dane did not request a waiver. It's not in its application. It is not referred to in the ZBA's decision. The ZBA's decision does not even refer to section 385, and the board made no attempt to make any of the findings required by that section.
Well, what is the parking requirement for the current use as a lodging house? Is it 20 spaces?
I believe, Your Honor, I'm not sure. I know that there's only 4 spaces at the building
Right,
presently.
but if they were to comply with the parking requirements of the ordinance, I saw in one of the briefs that they said that the current requirement would be 20 spaces. So a waiver, if that's correct, a waiver would not be required because the number of required spaces has been reduced.
Because you're referring to what the number of spaces that would be required if the existing use were.
Correct. Correct. You don't agree that it's 20 spaces as someone represented?
It may well be that if a new lodging house was constructed, it would be required to have 1 space per bedroom. I don't know off the top of my head.
We could contact the old owners. We know the old owners. We know old owners.
No, well, let's just assume that under the ordinance, a boarding house with 20 rooms would require 20 parking spaces. Let's just assume that. Then the developer wouldn't need to seek a waiver because the number of required spaces would be reduced from 20 to, what is it, 12?
5.
5. No, the number of required spaces.
Well, the number of required would be 12. You're correct.
So they wouldn't need a waiver, but isn't the fact that there's provision for a waiver, doesn't that necessarily imply that strict compliance with the parking requirements are not required when you're seeking to substitute one non-conforming use for another?
The fact that a waiver is available would imply that that is a possibility. But as I said, they did not seek a waiver, and the board did not make the findings required to grant a waiver.
Okay, but the waiver is only required if you're increasing the number of spaces, which, unless the 20 required spaces is incorrect.
I have to concede that if you're, there's 4 spaces there now, but I have to concede that if you're saying that it's an increase, that it's essentially a decrease in parking, I guess I have to defer to you. I view it as an increase from 4 to 12.
Okay.
And historically, the lodging house has not used really any spaces, has not used more than the 4 spaces that are on its driveway. If I may, I'll proceed to my second issue, which is whether the ZBA complied with all of the requirements of the ordinance in granting the special permit. The ordinance sets out 6 criteria to be considered in granting special permits. The 5th criterion is that there is no valid objections from abutting property owners based on demonstrable fact. This criterion sets a high bar about whose objections are to be considered. These are not objections from the neighborhood generally, but only abutting property owners. And Elizabeth and I are such abutting property owners. In its brief, 68 Dane asks who gets to decide what is a valid objection. I note that no one has raised the issue about whether or not our objections are in fact valid. And Judge Fahey, in her decision, actually determined that our objections were valid. But where we differ from her is that she believes that the ZBA could overrule those objections. We read the ordinance to say that if we've articulated a valid good faith objection as abutters, that the special permit cannot be issued. And in our case, we would not.
Go ahead, Judge Singh.
When you say that the judge agreed that you had a valid objection, can you point specifically to that and articulate what is the valid objection that the judge found?
She referred to our objection as being valid in her judgment at Record Appendix 42. And also in her findings of fact, rulings of law and order at 9, she says, plaintiff's primary objection throughout, even going back to an initial neighborhood meeting, then in his letters to the ZBA, and then in his testimony, was the poor design of the parking. She says, Mr. SCHLEIN was correct, and the 6 spaces do not fit. At the moment, Section 391B, which is this, as she says, is the special permit prerequisite requiring no valid objections from abutting property owners based on demonstrable fact, may tilt in plaintiff's favor. That is something with which the ZBA has to deal, at least in the first instance. So she found our objections to be valid, but she ruled that the ZBA had the power to overrule our objections. We respectfully submit that reads out Section 5 in its entirety. And if the ZBA is permitted to overrule valid abutter objections, then why do we have the section at all? Because why should the ZBA even have to consider that?
So, Mr. SCHLEIN, that comes from Beverly Zoning Ordinance 300-91B sub 5.
Right. Do
you happen to know whether that ordinance is common to other jurisdictions? In other words, do other cities and towns adopted that same ordinance?
I've done some zoning work in my practice, and I'm not familiar with it. When I read it, and this is one of the reasons I've emphasized it throughout, it does seem that the intent of the ordinance was to give an immediate abutter essentially a veto power. And I know that seems pretty strong, and sitting here as an abutter, we're claiming a veto power. But I think that's what the ordinance was said, and that's why it's not limited to parties in interest or neighbors or people affected. It's abutters.
Right. So it begs my next question, which I think you would have cited the case if it exists. But are there any cases interpreting what the meaning of that language is, whether it's in respect to? Well,
I don't have.
That's my question.
I'm sorry, Your Honor, I don't have one.
Okay. I will ask the appellees the same question.
So we ask that we also call to the court's attention that this result that the ZBA has provided requires that parking, because no one doubts that there'll be more than 6 cars associated with this condominium, that this parking is dumped on the public streets, on the neighborhood, on the beach down the street, the public parking that's available there, and jams that up. And we think that is not that's not appropriate. We think that the intensity of the use is too much. It should be 3 units would permit it to have the 6 parking spaces required by the zoning ordinance. And so we ask the court in this instance to make the determination that our objections are valid, as the court did below, but we differ from the court below in saying that we think that this means that the special permit could not be issued, and we ask the court to overturn the grant of the special permit. Thank you.
Thank you. Let me check with the panel. Any further questions for Mr. SCHLEIN? Seeing none, thank you very much for your brief and your argument, sir. And we will now hear from counsel for the appellee. First, Attorney Femino.
Good morning, Your Honors. My name is Len Femino for 68 Dane Street LLC. To put this all in perspective, in my office, we have an artist's rendition of, it's called A View of the City of Beverly, from up above in the air. And it shows all the details of all the streets and all the buildings in Beverly back in 1886. And it includes the area at issue today and the entire downtown. And it's so obvious when looking at this rendition, like so many other municipalities in Massachusetts, Beverly is an old city. It was once part of Salem. It goes back to 1621. And most all the properties in Beverly are non-conforming. It's a big issue. And in this rendition, once you leave the center of town with all the crowding back in 1886, and you look beyond Bass River, you see farms. And you know what's coming later, it's going to be filled. So non-conforming properties are, in essence, everything about the city of Salem in Beverly. And in order for Beverly to continue to evolve and to continue to stay vibrant within a community, to be able to update and improve, you need to have the protections of 48 Section 6 and Article 12. And in this case, 68 Dane, you should know, is the most egregious non-conforming structuring use in the city of Beverly.
Counsel, the Schleins, I take it, do not disagree that it would be better to have this development. It's a matter of the scale and the impact that would have on the community. So there's no disagreement that this property needs to be rehabbed and people are welcoming that somebody is willing to come in and do it. But the question is the impact on the community, and particularly this parking issue.
So again, when you look at this rooming house, it's a 7,000 square foot building in an R6 zone, which most of the lots is 6,000 square feet, frontage of 50 to 60 feet. This building is almost 2,000 square feet larger than anything else in the neighborhood. And it currently has 20 bedrooms. And that means under the ordinance, 20 parking spaces, which it does not have. It never has. It has 3 or 4. And we're going to reduce it to 13. So that is.
But that's a fiction. You know, that's really a fiction. It doesn't have 20 spaces. You are not truly reducing 20 to 4.
If it was, so yeah, so we have a structure that has 20 bedrooms. And pursuant to Article 12, we're going from 20 bedrooms to 13. That's a fact. That's what the ZBA, the courts are to focus on. I would suggest that fact alone, if we did not change parking at all, the ZBA could waive the parking and say that's enough.
But you didn't seek a waiver.
Yes. Well, waiver seeking is with the planning board. I don't hear ZBA seek waivers. They have the ability under Article 12 to waive parking completely when there's a finding, as the court found de novo, that on a beautiful Friday afternoon, on a beach day where it's sunny and warm, and the judge came to the site and walked around the block, there was plenty of parking throughout all the public streets.
Counsel, was there any sort of study done regarding the impact of this parking issue on the community?
No study done.
So it was appropriate to make a finding based on a judge walking out there on one afternoon?
Well, it's appropriate, I would suggest, Your Honors, for the ZBA, the governing body that knows its community better than anyone else. the body that sits twice a month and hears zoning cases, they actually knows this property because in its past, it's had some bad things happen there. To know what's best for the citizens of the city of Beverly, to make that determination that this use change comes squarely under the purpose clause of Article 12. Understand, Your Honors, we have 10 pages of an article that not only has zoning stuff in it, it has a definition clause, which includes parking. They get to deal with the issue of parking. For
There's no question that they have wide discretion in this area, but it still must be grounded in something, right? I mean, the determination that, you know, ordinarily 2 spots are required. In this instance, the determination is that 6 spots are sufficient, but in fact, it's not 6 spots, it's 5 spots. Doesn't that have to be grounded in something? Could we just say maybe no spots when you're putting 6 condominium units in? Where does it end?
Right, there's a building 2 blocks away that was part of the evidence, and it's one of the exhibits in the appendix, that is a building of 31 units and no parking available. Everybody parks on the street. That building's been there about 90 years and is allowed to exist. This building, the former rooming house, is going to be allowed to exist with the discretion of the ZBA, with the powers contained in its own ordinance, which is commonplace that they made these findings. When you look at the decision of the ZBA, when you look at the trial record, which you don't see much, it was all about parking. When the judge took the view, it was all about parking. We staked out the spots and showed it all. There was, during the first hearing, one of the members of the ZBA, Caldwell, who is an assistant city solicitor in the city of Beverly, commented that it's the size of the building that makes the parking issue on the lot what it is. So,
but aren't you actually increasing the size?
No, we're
You
not.
talk about how great how big this property is, but aren't you actually in your plans increasing the size further?
No, we're staying within the footprint. This is important. We stay within the footprint, which opens it all up. And again, under this article, we're allowed to increase the area inside the building by 25% as of right, which is what we're doing. It's actually less. It's about 12%. If I remember this correctly. We're putting on the 3rd floor, the building kind of stops halfway back. And so they're allowed to add some space there. That's going to be the largest unit. Which is
you're adding approximately 700 plus square feet to the building.
Yes. So that's allowed, again, under this article to do this. And it's for the ZBA to determine if that's okay. And they did. So,
but when they determine that that's okay, what is that grounded in? The discretion has to be grounded in some facts. On what basis did they determine that that's okay?
They held a public hearing. Nobody opposed it. They heard testimony of an architect, lawyers. They had photographs. They had plans. They saw the drawings. They look at it all. They see a property that's going to add 108 feet of pavement, driveway, like everyone else in the neighborhood. All those photographs at the back of the appendix show that even Mr. and Mrs. SCHLEIN have a driveway that abuts their property. It's not 5-foot setback like it says in the ordinance it's supposed to be. It's a non-conforming parking. And then they have a 2-car garage in the back, no setbacks, again, not conforming. They're allowed, they're grandfathered in. And why should they be grandfathered in? And now you're going to stifle the city of Beverly from being able to cause improvements to lessen congestion and lessen nonconformity. I'll stop. Thank you.
Actually, Attorney Femino, I have a question for you. Thank you. So
I'm showing, I thought it was Mr. Corrigan's. I'm sorry.
No, that's okay. I have a question for you, and that is, I asked the appellant about the Beverly zoning ordinance section 391B5.
Yes,
Obviously, it states, quote, that there are no valid objections from abutting property owners based on demonstrable fact, end quote. In your experience, is that zoning ordinance common to other cities and towns?
I've been involved in zoning for 39 years and I've represented the city of Salem for about 30. And those elements on special permits are very common. Whether I've never really analyzed each one, I would contend.
Well,
all these,
before you might just answer my first question, I'll let you go, but have you seen that specific provision in an ordinance in other cities and towns?
you mean that phrase?
Yes, that there are no valid objections from abutting property owners based on demonstrable fact. Have you seen that language or very similar language in other ordinances?
I would say similar language, but I don't, top of my head right now, I couldn't state anything.
Have you ever seen any place where that is defined or explained or explored in any way?
No.
Thank you.
Thank you.
Let me make sure the panel has no further questions for Attorney Femino. Seeing none, Attorney Corridan.
Good morning, Justices. May it please the court.
Could you start with my question, please? The exact same question.
Certainly. I'm not familiar with, I don't think that I've seen it specifically iterated the same way in other communities. I do know, to echo Attorney Femino's view of it, that these conditions are manifested in different articulations. So there are criteria generally from town to town, but they do differ. And I would suggest that what's important for our case is the ordinance that was adopted by the city of Beverly.
Well, doesn't the language of that ordinance suggest pretty broad language and pretty definitive language?
Intentionally so.
To protect the abutters, correct?
Well, no, I mean, the way that the city views this ordinance is as permissive, informative conditions. In other words, when section B starts in that ordinance, Your Honor, it suggests before taking final action on an application for special permit uses, the Board of Appeals and Planning Board shall consider whether the following other conditions are met. And that's consistent with deferring to the judgment of the objective judgment of the ZBA in determining whether or not the special permit should be approved. And if you go through to number 5, it's true that the use of the word valid would intimate to a casual reader one way or another they have a valid objection, but that's only viewed subjectively from an abutter as to whether or not it's valid. And in no way does an abutter in the approval of a special permit have any kind of veto authority over the judgment of the ZBA.
So you're saying all of these, the only thing that was required was a consideration of this issue, and you're saying that it's clear from the judge's decision that this was considered.
Yes, Your Honor. And the lower court actually articulated it as a valid consideration or issue or concern. But I would suggest also that the ZBA is empowered to both decide what a valid concern is in their own right, and even if they decide it's a valid concern, could then go ahead and still approve the special permit notwithstanding. So
it's interesting. The language doesn't just say that the board shall consider it. It says shall consider whether the following conditions are met.
Well, I can say that if any abutter is allowed to raise a valid concern, then no special permit would ever be issued in Beverly again.
It does beg that question. You're right.
So in essence, if it is read that way, it would be invalid, probably. So we read it and have read it as permissive, informative conditions, informing a volunteer board as to what issues they should be considering in whether or not they approve a special permit. And in addition to that, as to the parking issue, if I can move on to that, parking is expressly contemplated by section 380-82 for non-conforming uses. And the whole reason that there's a non-conforming use section is because it doesn't conform with the rest of the zoning code. So why would you look to the rest of the zoning code for parking restrictions? It's contemplated that, of course, it's an unusual circumstance, so you have to address it unusually. And in this particular case, I would zero in on the fact that these 6 or 5 parking spots at the end of it, apparently 5, are not overly intrusive compared to the non-conforming use that existed prior and all of the other elements that the ZBA can consider besides parking.
Sorry, Attorney Corden, your time has expired.
Thank you.
No question?
The panel has some questions for you.
Can you address the application of section 85 specifically regarding non-conforming off-street parking and loading?
Yes, Judge. I would just say that that is an applicable provision to the ZBA's consideration, and I would say that in their judgment, the proposal satisfied that section as well.
Well, according to this, wasn't there a waiver process that's required according to section 85 because there's some increase?
I can't respond to that, Judge. I would say that the whole section acts as a whole, and if there is a waiver process, they ignored it because they didn't think this was a valid concern to begin with, even before the trial. So they were asked after trial, are you satisfied? And they were still of the same opinion that parking didn't actually compel a further inquiry.
I mean, is there a net increase in the number of required parking spaces?
Well,
that's in the language of section 85.
I think the number of parking spaces allowed by the previous use and allowed by the new use, there's a net decrease.
Required, right?
Well, it's a special permit, so we're allowing.
Okay, but what's the number of parking spaces required by the current use?
I thought it was in excess of 4, but I can't answer that specifically.
Okay.
Seeing no further questions, thank you, counsel. I'd like to thank the Schleins. In the case of
And we are back live and on the record.
good morning. Calling our fifth and final case today, Shaw versus Shaw, docket 2020 P0648. We will hear first from counsel for the appellant, Attorney EUGENE.
Good morning. My name is KRISTINE EUGENE. I'm appearing on behalf of the appellant Arthur Shaw, defendant in the trial court modification action. There are several issues raised in Mr. Shaw's brief, but the major issue in this appeal is the trial judge's inappropriate inclusion and exclusion of various sources of income of the parties and how that inappropriate treatment impacted the overall alimony order, as well as the consideration Mr. Shaw received for his payment towards college expenses per the terms of their separation agreement.
Attorney EUGENE, let me interrupt you. Would you agree that resolution of this issue turns in large part, if not solely, on whether or not this is accurately classified as a complaint for modification or as an initial alimony order?
Yes, that's a major part of it. There's other parts, but yes.
Sorry to interrupt, but that begs my next question, which is it correct that prior counsel, I know you weren't trial counsel, but that prior counsel argued to the trial judge that this complaint is actually one for modification under Chapter 208, Section 37?
Well, it's a little unclear. I think that Mr. Shaw's trial counsel always argued that there was no substantial change in circumstance. She always argued that all income from all sources should be included for purposes of calculating the alimony award. Ms. Shaw also argued on her own that she did not need to prove a change in circumstance, and thus her argument essentially was that this was an initial complaint for alimony.
Well, I looked through the transcript and I can't see, they really just presented testimony, not arguments. My understanding from Attorney Marshall's brief is that in the post-trial briefs, it was argued that this is a complaint for modification, and that's what prior counsel to you argued. We don't have the post-trial briefs in the record, do we?
No. So
what we do have then is the judge's findings of fact and rulings of law, and I think the judge made the comment that your counsel, prior counsel to you, argued that this was a complaint for modification. If that's the record before us, how do we get around that?
Well, a couple reasons, Your Honor. So she also made the comment that it was the wife's position that she's entitled to alimony, whether or not there has been a change of circumstance. And you'll see that on page 8. So if the wife was arguing that that she's entitled to alimony, regardless of whether there was a change in circumstance, the type of complaint she filed is not dispositive. So although she filed a complaint for modification, her argument was essentially that she didn't need to prove a material change in circumstance, and therefore she was essentially arguing that this is an initial complaint for alimony. Additionally, the trial court then goes on to say it is not the wife's burden to prove a substantial and material change in circumstance. So because the trial court is then treating this as an initial complaint for modification, we have to then apply the correct standard regardless of what Mr. Shaw argued at
the judge basically punted and said, even if she does have to show a material change in circumstances, she's done so. And the problem with the argument as far as whether the issue was preserved is that the way that the issue was teed up to the judge was, is this a modification or is this an initial request for the purpose of determining whether she has to prove a material change, right? But I haven't seen anywhere in the decision where the issue of inclusion or exclusion of income was ever presented to the judge, right? Because in order for your predecessor counsel to preserve this issue, he or she would have had to argue, Judge, this is a modification complaint and wife hasn't shown a material change in circumstances, so she's not entitled to alimony. In the alternative, were you to find that this is in fact an initial request, you should include her overtime income in the calculation. And there would have had to be alternative arguments. And where in the record can you point us to anywhere where that argument was presented?
Well, as Justice Neyman pointed out, there wasn't really arguments in the record. There was the presentation of facts and information. And when you look at the totality of the judge's findings, including the fact that she started, and this isn't specifically addressed in the brief, but on page 3 of her judgment, she indicates that the durational limit will start as of June 1st, 2018. She then states on page 9 of her judgment that the duration of the alimony obligation would begin as of the date of the judgment, so February 13th, 2020. So in that context, she's treating it as an initial complaint for alimony. So if we're looking at it for purposes of duration, is it an initial complaint for alimony or is it a complaint for modification? If we're looking at it for purposes of income inclusion, is it an initial complaint for alimony or is it a complaint for modification? And to that end, Mr. Shaw is seeking that there be a uniform treatment and that the correct standard is applied based on the judge's treatment of this complaint as an initial complaint for alimony. And it's synonymous to the Snow case. And further, it's unlike Buckley, it's unlike the Vidensky case, where that court specifically found that there were material changes since the date of the divorce judgment. Mr. Vidensky, was a high earner at the time of divorce. He then lost his job and then needed alimony. Here, there was a specific finding that Ms. Shaw needed alimony at the time of the divorce, but then she deferred it. So the judge's reading the memorandum when read in a whole, and when you look at how she treated the change in circumstance, how she looked at the 53A factors, how she addressed the wife's need at the time of the divorce, how she calculated the duration, all lead to the fact that this is an initial complaint for alimony, and therefore her treatment of the wife's overtime income was incorrect because she used Section 54 in excluding the wife's overtime income and then recalculating it back in to give Mr. Shaw credit. And that was an error. And again, whether it was specifically argued by Mr. Shaw, I don't think I think we're putting a lot of weight on that when the point is there needs to be uniformity in this judgment, and we can't treat it as an initial complaint for duration purposes or for standards, and that material changes in circumstance, but then treat it as a complaint for modification when we're looking at what income to include or exclude. So that's the issue there. And when you look at that, and you look at how the court treated the complaint, she was required then under Snow to give Mr. Shaw consideration for his payment towards college by factoring in Ms. Shaw's overtime income that should have already been considered. So by refactoring in something that should have already been considered when calculating the alimony award, he didn't receive any meaningful consideration that he had bargained for per the terms of their—
But in Snow did not involve, there was no separation agreement in Snow. I mean, alimony was just never considered in the original proceeding. Why isn't this case more like Buckley, where the parties entered into an agreement here that expressly referenced the issue of alimony? It's the same as in Buckley.
Well, in Buckley, the court found that the reading of the agreement required that there be a material change in circumstance. Buckley predated the Alimony Reform Act. Like in Snow, neither party pled alimony in the initial divorce. It wasn't pled by Mr. Shaw. It wasn't pled by Ms. Shaw. And it essentially, they deferred it like in Snow, and unlike in Buckley, where there was a need at the time of the divorce, and there was a significant change that essentially everyone agreed that there was.
Well, Buckley found that it was implicit in the agreement that they agreed to a material change in circumstances standard. I think the agreement here is susceptible to that reading, but you say that Buckley precedes the Alimony Reform Act. How does the act change the analysis?
Well, it changes the definition of income when it looks towards the guidelines. And again,
how does the act change the analysis of whether we consider this to be a modification or an initial request?
I don't know that it necessarily changes that analysis, but I do think Snow is more on point with the judge's interpretation. And again, when you read the agreement as a whole, she says the parties didn't need to, there didn't need to be a change like there was in Buckley. In Buckley, there was the implicit agreement that they wouldn't come back unless there was a change. Here, the trial court says there doesn't need to be a change. That wasn't what the parties bargained for. The wife was entitled to alimony upon the occurrence of one of these triggering events, regardless of whether she proved a material change in circumstance. And therefore, this complaint is akin to an initial complaint for alimony. Therefore, she treated it akin to initial complaint for alimony pursuant to Section 49 under the durational limits. And it should have been treated that same way under Section 54B for the purposes of including or excluding overtime income. And that's the major issue. And if you look at it another way, if the court had treated this as a modification, then the judgment is just inconsistent. If the court's using June 1st, 2018 or February 13th, 2020 as the date alimony is awarded for purposes of duration under 49B, the same date needs to then be used for consideration of a party's income under 54B, which states that income is not considered if the overtime began after the entry of the initial order. So if the initial order begins to run on June 1st, 2018 or February 13th, 2020, then the wife's income predates that and should have been considered anyway. So again, this isn't an issue of waiver. We're simply asking the court to apply the appropriate standard, like consistent with Snow, as consistent with an initial complaint for alimony. If you look further into the inclusion, exclusion of certain income, the judge also made additional errors when she included Mr. Shaw's income from overtime due to the town's strike in his income for purposes of calculating alimony. In considering income, the court must give consideration to the history of the income and the expectation that it would continue to be available to Mr. Shaw. So 53C defines income pursuant to the child support guidelines. So while the language of the guidelines is discretionary as to the inclusion of overtime income for purposes of calculating support, the court still has to give due consideration to the fact that Mr. Shaw's income from that strike would not be available to him in paying a support order, thus impacting his overall ability to pay. So the trial judge found that Mr. Shaw had an additional $615 per week in a surplus that could be used to pay alimony, but $500 or around $500 at $479 would not be available to Mr. Shaw moving forward, a fact that the court didn't consider and therefore inappropriately calculating his ability to pay. I also want to—
Counsel, let me interrupt you. I want to ask you about the motion to amend.
Sure.
Am I correct that the sole purpose of the motion to amend was for the judge to add a termination date regard to the payment of alimony? It's to add it to the judgment, correct? A termination date?
Correct. That was the main, yes, the sole purpose of the motion to amend.
So let me ask you this. The judge, I think you're right, it's not in the judgment, but in the judge's memorandum of decision, and right now I'm at Record Appendix 41, the judge said, as the agreement provides that alimony shall be paid as set forth in 208-48-54, and now I'm quoting, the duration of his alimony obligation is 806.25 weeks from and after the date of this judgment, unless earlier terminated pursuant to the agreed statutory provisions, end quote. Would you agree that that fairly describes the termination date?
Well, a couple things. On page 3 of her judgment, it's inconsistent because she states that it's as of June 1st, 2018. When you look
Page
at
3 of her judgment or her memorandum of decision?
Excuse me, her memorandum, and that's Record Appendix 35. If you look at the top, so it's internally inconsistent. So it would need to be addressed. I also don't think that that's accurate under the Internal Revenue Code, and there needs to be a specific termination date in the judgment. And the motion to amend was served timely. I know that wasn't your question, but it was served timely. Rule 6 applies to all of the rules, and Rule 6 states that if the date falls on a Saturday, Sunday, or legal holiday, it's extended Monday. So he did serve that timely, and without the clarification specifically put in the judgment, there's potential unintended tax consequences. So Mr. Shaw, I see my time's up, but Mr. Shaw should be entitled to the deductibility if it was the intention that this was an alimony order post 2017 tax reform and as of the February 13th, 2020 judgment, and that needs to be specified in the judgment or else there are potential issues with that.
Let me see if the panel has any further questions for you. Seeing none, thank you for your argument. And we'll hear from Attorney Marshall, counsel for the appellate.
You're on mute, counsel. You're on mute.
Okay, let's check with our clerk and see if she can take you off mute.
Here we go. Okay, sorry. I think the fundamental issue or error in Mr. Shaw's position is taking the language in Judge Roberts' memorandum, where she references the lack of need to prove a material and substantial change of circumstances, as an indication that that means she intended it to be or treated as an initial complaint. I don't read that at all, and I don't believe that that was her intent. I think if you look at Clement, this case is almost exactly on point as Clement. The agreement clearly anticipates alimony is going to be paid. I will point out in the separation agreement under life insurance, there's a specific clause requiring Mr. Shaw to maintain life insurance for so long as he has to pay alimony to the wife. The language about alimony clearly says there won't be any alimony until, and then sets forth the trigger elements. This is not a case of an initial alimony complaint. This is a situation where there's a deferred alimony complaint. where it was deferred until such time as one of the triggering events occurred.
The judge treated this as an either or in her findings of fact and rulings of law. It seems to me. She said it really doesn't matter, but I find that she essentially found both, which begs the question, which is what was argued to her, what was raised and what was argued. It seems to me we have the transcript in the record, and there really was an argument. You represent in your briefs that in the post-trial briefs, prior counsel for the appellant argued for change, that there was argued that there must be a change of circumstances shown. But we don't have those briefs before us. So in terms of the record that we have here, is there any place where these arguments are articulated by the parties?
I don't believe in the actual trial testimony. I had the advantage of being trial counsel and having met with the judge at the pretrial when a lot of these discussions actually took place,
right.
Which is not part of the record.
Right. So your representation to us is that on the record before us that we have, and that's what we're bound by, we don't know what the parties argued to the judge, other than what the judge said in her decision.
Other than what the judge said in the decision, where she says the language of the agreement has these triggering events. Given that outline, given that reality, I don't think that they even had to prove a substantial material change in circumstances, but they did. And this is a substantial material change in circumstances, and therefore, and goes forward and treats it as she should have as a modification. Because the language about alimony is so clear, it's anticipated in the agreement. There's not going to be present alimony because he's paying for college expenses. There will be a judgment in the future. How much that will be determined by the court. The life insurance has to be maintained. It's in the agreement, in the parties' agreement, their own understandings. It's pretty clear that they understood that this was mother's way of ensuring that girls would get their educations paid for by father, and she would defer her receipt of alimony until that was ended and over.
You said this case was like Clement. Is that cited in your brief?
It's actually cited in, it came down just very recently. It is cited in my brother's reply brief.
Okay.
It's
that's all right. If it's in the reply.
Why can I never get it when I, okay.
It's in the reply brief. It's dated October 16th, 2020. We have it.
Thank
Precisely,
you.
right. Clements versus Kelnick. Yes. And it has to do where they waive past, present, and future alimony, but reserve the right to seek alimony in the event of the lack of a sale, or the property didn't sell for what they anticipated it for. And given that, they said clearly there was a knowledge that their alimony was an issue, they dealt with it, and they deferred it until after the sale of the property. In this particular place, I think it's even clearer. The parties specifically set forth there will not be alimony at this time, but as of June 1st of 2018, or the happenstance of other specific triggers, there would be an alimony amount. The only question would be how much, and that would be up to the judge to decide. And therefore, this is a situation of deferred alimony, not a first time look at it, not a question. Alimony was very much discussed at the time of the divorce. There was clearly a need, and it was clearly before the court. Again, nothing in the transcript of this present case, nothing that was included in the appendix would provide that information, except for the separation agreement itself, which clearly makes reference to alimony in several different places. Because of that, I don't think that there was any error whatsoever in excluding the overtime income from the wife. However, the irony of this case is, even if one were to include the alimony income of the wife, the alimony order that was put forth by this court, by this judge, $400 a week, represents approximately 15% of the difference between his income and hers. It's not an outrageous order. And that's including all of her overtime income. The judge heard all the facts about everybody's incomes. She heard all the facts about husband's overtime income. She was aware of the fact, and it was in evidence, that his income the year before was $208,000, that his income this year was likely to be more than that. She had the evidence before her of the time of the divorce. His income was $165,000 a year. It had been slightly higher, $177,000 the year prior to the divorce. She was aware that there was a large component of overtime in his income. I will also point out that between the divorce and the modification trial, his base income had increased by almost $500 a week. So that in and of itself was not only a substantial material change in circumstances, but would more than cover the alimony. So this notion of that she somehow included too much income from his part, I even did the calculations excluding that overtime income. It would still, the alimony order, 30% of the difference between his income and hers would still be over $600 a week. So it is so, I won't say absurd, but the numbers just.
You're saying it's within the range of discretion.
Well within the range. I mean, well below the range of discretion. So in terms of fairness and reasonableness and how this judge very carefully considered each and every one of the factors, I think it's pretty clear that she clearly understood where the parties' situations was, their financial situations. She made repeated references to the decrease in the wife's lifestyle since the divorce. The overtime in the record, there's I think one or two lines in the testimony about the supposed strike. It's not highlighted. He did not ever present a single tax return. He never presented a single wage statement from his employer. As part of discovery, he didn't present a lot of stuff, and that was part of the issue and the problem in this case. So then we get to the consideration for college. The testimony, I think, again, talk about discretionary issues and factors. It says consideration. It doesn't say credit. It says consideration. 4 years took place between the divorce and the modification being filed or starting June 1st of 2018. It was almost 4 years. It was those 4 years when the second child completed her education, the first child finished her last year. The parties knew that he would be spending approximately $100,000, but there was always a possibility that it could be considerably more. The judge gave him a credit in her analysis. She gave Mr. Shaw a credit of almost $300 a week, over $15,000 a year for college payments that at the best case, and again, because of the lack of information, his testimony was approximately or slightly over $100,000. That's what he spent over the 4-year period. I suggest, most respectfully, a credit Mrs. Shaw's share of $50,000 would have been about, comes out to be $12,500 a year for those 4 years. She waived alimony during that time. She didn't receive alimony during that time. I suggest, since she was making $165,000 a year and she was making less than $60,000 a year, that would not have been an unreasonable amount of alimony that she deferred. So when you look at the totality of the circumstances, this case, I think, is pretty clear. The man makes nearly $200,000 a year, even without the strike income. The wife makes $60,000 a year, including all of her overtime. There's a huge disparity. It was a long-term marriage. They raised children, 3 children together. And there was a need for an alimony order. And I think the judge listened to it all and came up with a number that is well within any of the reasonable limits.
Let me ask you about the motion to amend. First of all, do you agree that generally the termination date for alimony is delineated in the judgment itself?
I think that there were two, usually it can be. That was not tried in this case. You will not see in the transcript any discussion about when these parties began living together, when they began their relationship, their economic relationship, their premarital relationship, all of which is included and anticipated in the alimony statute. We didn't go into those factors. Frankly, it was quite clear because the durational limits would go past his age of 67, so it seemed to be a rather moot point.
Well, let's then move to the motion to amend. You're saying it wasn't timely because service is different than filing. So my question is, what authority do you have for the proposition that Rule 6A regarding computation of time periods does not apply to filings made under Rule 9E?
I do not have any. I looked, I consulted with the person who helped draft this brief, and I don't have any specific basis for that. Simply that the rule 6 goes to the commencement of actions, the service of process of actions. Rule 59E is one of those rules that it cannot be enlarged. The finality of the judgment is crucial. The necessity for getting notice out to everyone is crucial. Frankly, I think that the interpretation of the bar as a whole has always been that the 10 days is the 10 days is the 10 days.
That's not my experience. I mean, Rule 6 says quite broadly that it applies where there's any period of time that's prescribed by these rules. I mean, I don't know how you get around that language.
And again, not to be facetious, but I am pretty much, have been for my career, a trial attorney in the probate and family court. I'm not an appellate specialist, but I think it's just generally interpreted that way. I will also, however, point out that in terms of the substance of the motion, there was no evidence of testimony about durational limits, the question. There was also no evidence whatsoever about the tax consequences. And Mr. Shaw presented no witnesses. He presented no tax returns. He presented no expert. So all of the arguments made in that motion are post-judgment evidence that he never even raised the issue during the trial. And he presented no evidence upon which the judge could have made a determination of that. And that is the thrust of his motion. I think the judge, knowing that the durational limits had not been fleshed out completely and the tax issue had not been fleshed out completely, she entered a judgment simply as to the amount that it should be at this time, assuming that the durational limits would come up as an issue down the road if and when Mr. Shaw raised it to seek to terminate it. So, and in terms of tax consequences, that's, again, he has a duty to present that evidence and information if he wants the court to consider it, and he did not.
If there are any further questions from the panel. Seeing none, I want to thank counsel for both parties. We appreciate your